The Trafficking, Prevention, Protection and Rehabilitation of Persons Bill 2018 was introduced and passed in Lok Sabha in July this year. It is currently pending in Rajya Sabha. The bill provides for the investigation of trafficking cases and rescue and rehabilitation of trafficked victims. The bill includes trafficking for various purposes, including for sexual exploitation, slavery, or forced removal of organs. In addition, the bill considers trafficking for certain purposes, such as for begging or for inducing early sexual maturity, as aggravated forms of trafficking. These forms of trafficking attract a higher punishment. In order to punish trafficking, the bill provides for the establishment of investigation authorities and rehabilitation authorities at the district, state, and national level. Further, protection homes and rehabilitation homes may be set up in order to provide long-term care and rehabilitation to victims of trafficking. Note that the current bill does not replace but adds to the existing legal framework. At present, there are a broad range of laws that deal with bonded labor, commercial sexual exploitation, and exploitation of children. Each of these laws specify their own procedure for enforcement and rehabilitation. One of the challenges with the bill is that these laws will continue to be in force after the bill comes into effect. Since each of these laws prescribe their own procedure for enforcement and rehabilitation, it is not clear as to which procedure will apply to certain cases of trafficking. This may result in overlap in the implementation of laws. For example, under the Immoral Traffic Prevention Act 1986, protective homes may be set up for providing rehabilitation to victims of sexual exploitation. The bill also provides for the setting up of protection homes to provide rehabilitation to victims of trafficking for sexual exploitation. When a victim of sexual exploitation is rescued, it is unclear as to which of these homes she will be sent to. The bill also imposes penalties for various offences connected with trafficking. For instance, if trafficking is committed on a property, it will be presumed that the owner of the premise was aware and had knowledge of the commission of the offence. The implication of this would be that if the owner lives in another city and lets out the property to a person who is found to be detaining girls for the purposes of sexual exploitation, then the owner will be presumed to have had knowledge about the commission of the offence on his property. In such circumstances, the owner will have to prove that he did not know about the commission of the offence on his property. This provision is a departure from the standard principle in criminal law that the guilt of the accused has to be proved and not presumed. There are other laws which presume the guilt of an owner of a property. However, such laws require the prosecution to prove certain facts before presuming the guilt of the accused. For instance, the Narcotic Drugs and Psychotropic Substances Act of 1985 punishes an owner if he knowingly allows an offence to be committed on his premise, and the knowledge is presumed on the part of the owner. However, the Act clarifies that the knowledge will only be presumed if the prosecution can prove that the accused was somehow connected with the circumstances of the case. So, for instance, an owner of a truck is not presumed guilty only because his truck was used for the transportation of drugs. However, if the owner was also driving the truck in which the drugs were transported, then his guilt may be presumed. The bill does not contain these safeguards, and therefore this provision may violate Article 21, which states that any law which deprives a person of his life or personal liberty must be fair and reasonable. For more information, please visit www.prsindia.org.